Legal and Privacy Brief for February 16, 2026. 5 European court and regulatory decisions involving GDPR compliance were catalogued this week across Lithuania, Germany, France, the Netherlands, and Romania, reflecting active enforcement and adjudication across multiple EU member states simultaneously. Debevoise and Plimpton flag a structural gap in standard B2B data agreements. AI tools now allow counterparties to train models on shared data and enter direct competition without triggering existing NDA or non-compete provisions. Security researcher Bruce Schneier introduces the Promptware Kill Chain framework, reframing LLM prompt injection as a multi-stage attack sequence with direct compliance implications for organizations deploying AI in regulated workflows. Here's the full breakdown of today's top legal and privacy stories. Next section, privacy developments. VDI Lithuania NR 3R219-2 13-1. E-Lithuania's State Data Protection Inspectorate VDI issued decision NR 3R219-2 13-1 E on February 6, 2026. The ruling is catalogued in GDPRUB as a GDPR enforcement decision. The original decision is published in Lithuanian on the VDI official site. Specific penalty amounts, the identity of the respondent, and the violation type are not disclosed in the extracted content, but the VDI handles administrative enforcement under Articles 83 and 58 of the GDPR. Compliance action. Organizations with Lithuanian operations or data subjects should obtain the full decision text. VDI enforcement decisions establish precedent for supervisory expectations in Lithuania. Review any pending DPA inquiries in the Baltic region against this decisions, framing once an English summary is posted to GDPRUB. Source: GDPRUB NR 3R219-2 13-1 E VDI original PDF. OLG Bamberg, Germany, 10U61/25E Germany's Higher Regional Court Bamberg, Oberlandesgericht Bamberg, issued a civil ruling in case 10U61/25E on or around January 21, 2026. The case is catalogued in GDPRUB as a GDPR-related court decision. Civil GDPR litigation at the OLG level in Germany typically involves claims for non-material damages under Article 82 GDPR, injunctive relief, or disputes over whether a data processing action was lawful. The original German text is published on Ruiz. No damages figure or ruling outcome is available from the extracted content. Compliance action. German appellate courts have been increasingly active on Article 82 GDPR non-material damages claims following the CJU Judicata and Nationale Agentia za Priehedheit decisions. Organizations processing data of German residents should track this decision for the damages threshold applied and the legal basis scrutinized. Review Ruiz for the full text. Source: GDPRUB Ruiz original. CA Paris, France, 25/04270, the Paris Court of Appeal, Cour d'appel de Paris, issued a ruling in case 25/04270. The GDPRUB entry references a Cour de Cassation source, which suggests the case involves either a cassation referral or an appeal touching data protection law at a high appellate level. French courts have been active in applying GDPR in the context of employee surveillance, algorithmic processing, and consent enforcement. The original French text is available through the Cour de Cassation's public decision portal. Specific parties, ruling, and any damages are not available from the extracted content. Compliance action. Organizations with French operations should monitor the Cour de Cassation for the published opinion, particularly if processing involves employee data, automated decision-making, or behavioral advertising. French appellate decisions can establish binding interpretation that the CNIL applies in subsequent enforcement. Source: GDPRUB Cour de Cassation original. RVS, Netherlands, 202203874/1/A3. The Netherlands Council of State, Raad van State, ruled in administrative case 202203874/1/A3 ICLI, NL, RVS 2026, 746, with GDPR implications. The AVG keyword in the Rechtspraak search maar data confirms the case involves the Algemeen Verordening Gegevensbescherming, GDPR, as enacted in Dutch law. The Council of State is the highest administrative court in the Netherlands and handles appeals against government data processing decisions. Administrative GDPR cases at this level often involve public registers, municipal data sharing, or law enforcement data access requests. The original Dutch decision is published on Rechtspraak, NL. Compliance action. Dutch public sector entities and organizations subject to Dutch administrative law should review this decision once an English summary is available. Council of State rulings bind Dutch administrative authorities and set the interpretive standard for how government bodies must apply GDPR in administrative contexts. Private organizations interacting with Dutch government databases or public registers should assess whether this ruling affects their access agreements. Source: GDP Rube Rechtspraak Original. CC Romania 04.02.2026 Romania's Constitutional Court, Curtea Constituțională, issued a decision on February 4, 2026, catalogued in GDP Rube with data protection relevance. Romania's Constitutional Court reviews legislation for conformity with constitutional provisions, which include fundamental rights to privacy under Article 26 and 28 of the Romanian Constitution. Constitutional Court decisions that intersect with GDPR frequently address domestic laws implementing data retention, national security data access, or biometric identification requirements. The original decision is in Romanian and published on the court's official communications portal. Compliance action. Organizations operating in Romania should track the full ruling once a summary is posted to GDP Rube. Romanian Constitutional Court decisions that invalidate or constrain domestic data legislation can affect compliance obligations under national implementing law, independent of GDPR proper. Review any compliance frameworks that rely on Romanian domestic law, e.g., Law 190/2018 implementing GDPR, for potential gaps created by the ruling. Source: GDP Rube Romanian CC Communications. Next section, regulatory guidance. AI is making everyone a potential competitor. Are your data contracts ready? Debevoise and Plimpton's data blog identifies a structural gap in standard B2B data agreements. NDAs and data use restrictions were designed for a competitive environment where counterparties remained in their defined business roles. AI changes this assumption. A vendor, partner, or supplier can now train models on data shared in the ordinary course of business, then deploy those models to enter markets previously exclusive to the disclosing party. Existing NDA provisions typically restrict disclosure to third parties and prohibit use outside the purpose of the agreement. But these clauses were drafted for human employees and defined business lines, not automated training pipelines. Non-compete provisions similarly cover specific business activities, not AI-mediated competitive development. The article's central point: enforcement of data use limitations has historically been low stakes, but the leverage an AI model can extract from a counterparty's shared data now makes these clauses material. Compliance action. Audit existing B2B contracts, NDA, vendor agreements, and data processing agreements for AI-specific use restrictions. Add clauses that explicitly prohibit counterparties from using shared data to train, fine-tune, or benchmark AI models, including third-party or foundation models. Define data use to cover synthetic data generation and model distillation. Establish data minimization practices in sharing arrangements to limit what a counterparty could train on. Procurement and legal teams should treat AI training prohibitions as standard boilerplate going forward. Source: Debevoise Data Blog. Next section, policy changes. The Promptware Kill chain Bruce Schneier, writing on Schneier on security, presents a new analytical framework called the Promptware Kill chain. Co-authored with academic collaborators, the piece reframes LLM prompt injection attacks as a multi-stage attack sequence, analogous to the Lockheed Martin cyber kill chain used in traditional threat analysis. The argument: the dominant framing of prompt injection as a single vulnerability obscures a more complex attack surface. The full attack chain involves multiple distinct stages, including reconnaissance of the LLM's access scope, payload embedding, execution trigger, and post-execution actions such as data exfiltration or process manipulation. Defenses targeting only input sanitization address one stage. Organizations deploying LLMs in regulated contexts and assuming vendor-provided injection filters constitute full coverage are exposed to the remaining stages. The compliance implication is direct. AI systems used in HIPAA, GLBA, FERPA, or GDPR-regulated workflows that are compromised through multi-stage promptware attacks can generate breach notification obligations. Compliance action: request documentation from AI vendors specifying which stages of the promptware kill chain their defenses address. Input sanitization alone is insufficient. For any LLM deployed in workflows that handle regulated data, conduct or commission a structured threat model against the full attack surface, not just prompt injection. Include promptware kill chain coverage as a line item in vendor security questionnaires. If LLMs are used in customer-facing or data processing roles, assess whether a multi-stage attack could constitute a data breach under applicable law and trigger notification requirements. Source: Schneier on security. Next section, compliance takeaways. AI training clauses are now standard contract hygiene. Existing B2B NDAs and data agreements do not prohibit counterparties from training AI models on shared data. Legal and procurement teams should add explicit AI training prohibitions to all new agreements and flag existing high-value contracts for renegotiation. Apply to vendor, partner, and customer agreements where competitive risk exists. European GDPR enforcement is broad and simultaneous. 5 GDPR-related decisions across Lithuania, Germany, France, the Netherlands, and Romania surfaced in 1 week. Organizations with EU operations should maintain active monitoring of GDPRUB and national DPA publications, not just CJU and EDP output. Member state courts and DPAs are developing jurisdiction-specific interpretations that affect compliance obligations independently of EU-level guidance. Dutch Council of State GDPR ruling warrants tracking. ICLI, NL, RVS 2026, 746 is an administrative GDPR case at the highest Dutch administrative court level. Public sector and semi-public entities in the Netherlands and private organizations with data-sharing relationships with Dutch government bodies should review the full ruling once translated. Romanian domestic GDPR law subject to constitutional review. The Romanian Constitutional Court's February 4 decision signals active fundamental rights scrutiny of data protection legislation. Compliance frameworks relying on Law 190/2018 or other Romanian domestic implementing measures should be checked for gaps if the court's ruling invalidates or modifies statutory provisions. LLM deployments require multi-stage threat modeling. The Promptware Kill Chain framework establishes that prompt injection filtering is one control, not a comprehensive defense. Any LLM in a regulated workflow, healthcare, financial services, legal, HR, needs a structured threat model covering the full attack surface. Build this requirement into AI procurement reviews and annual vendor assessments. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.